Good afternoon and hello to everyone attending the webinar today. I got a week off for July 4th when we didn't hold a webinar, so I haven't been here at the webinar for about a month, so it's good to be back. We have a great lineup today, which I will tell you about in just a sec, but before we do that, I want to tell you about a pop-up webinar that we're going to be offering this Thursday at noon. This is a follow-up to last week's weekly webinar where Laura Harshbarger talked about DEI considerations for employers in the light of the Supreme Court's decision on affirmative action. And we've received feedback that this is a topic of interest to many clients. And so Laura, together with Kurt, actually, who's on with us today, will be doing a webinar this Thursday about that topic. So the invitation for that just went out. Keep an eye out for it. If you're interested in that topic, which is extremely timely, go ahead and check that out on Thursday. So with that, I'll turn my attention to today's agenda. And we have 4 speakers. Well, that would include me. But starting out, we'll have Seth Gilbertson talking about pay transparency. That implementation date is coming up very shortly. So I want to make sure everyone's up to date on what they should be doing. Colin Leonard will tell us a bit about New York State WARN regulations that have been finalized. We did talk about them earlier when they were in draft form, but now they are final. And Kurt will be with us talking about a recent decision he was involved with involving Section 8 and landlords. And then I'll finish things out talking about the Freedom of Information Law. So with that, I'll turn it over to Seth to begin his presentation. Thanks for being here, Seth.
Thanks for having me again, Kristen and everybody. This is the 3rd time I think I've spoken to you all about this, and I think some of my colleagues have as well. But we are getting close to the implementation date. Next slide, please. We are officially less than 2 months out, and as we all know, the end of summer, sort of the last 2 months of summer here, the clock speeds up, the passage of time increases, and that September 17th date is going to be here before we know it. So now's the time to get serious about this if you haven't already. It is upon us. And just some reminders about the pay transparency law that's going to go into effect statewide on September 17th. This applies to all entities with 4 or more employees. So that's going to be the vast majority of certainly bond clients and all the employers in New York State out there. There is a limited exemption for temp firms, but unless you're one of them, it doesn't really apply, unlike some of the exceptions to the New York City law. So it's going to have broader coverage. It requires that we disclose a range of compensation in any job posting, that is the minimum and the maximum annual salary or hourly range that you in good faith expect that you're going to pay for the job that you're posting for, which would include promotion or transfer opportunities, as long as those are included in a written advertisement. We'll talk about that in just a minute. And the Department of Labor can issue civil penalties for noncompliance, $3,000 per violation. I will also tell you, you'll probably be included in a press release if you're one of the first few victims of the Department of Labor's regulatory endeavors in this area, because you bet they're going to try to go after a few non-compliant employers and sort of make an example out of them and issue a press release. So there'll be $3,000 plus some probably damage to reputation. Next slide, please. So the scope of the law again applies to a job promotion transfer opportunity that will be physically performed at least in part in New York State. It also includes remote and hybrid job opportunities, as long as they report to a supervisor or an office in New York. So we'll talk about preparing for that in a little bit. But again, this is going to be probably from New York State employers, New York State based employers. This is going to cover the wide majority of your employees. There are also, we'll just remember, many other states that have similar laws in effect. So I think if you're looking for opportunities to not apply this, it's probably past that time. I think this is probably going to be just sort of a nationwide standard pretty soon, given the size of the states that have already enacted similar laws. And now we have one in New York. My recommendation would be to just go ahead and accept it, that this is the new reality, and not really look for little areas where you can not apply it, whether that be remote or hybrid work, because many times you don't know where that employee is going to be based. And it is increasingly likely that they are going to be based in a state that has a pay transparency law of some sort, even if they are not reporting to a supervisor in New York. So I think the best course of action here is just sort of accept the reality that pay ranges should be posted for the majority of all opportunities that you're producing these days. So, and again, it applies to written sort of advertisements, a written description of employment opportunity. It doesn't apply to direct recruiting or promotional opportunities where you just promote somebody in the, within an office or within a position to a higher position. It's really got to be sort of something that you've opened for a pool of applicants to potentially apply for. Next slide, please. What do we want to do? If you are looking for clarity on, specific jobs that you do have to post for, you can map out your reporting structures. It may be a good opportunity just to do that anyway, kind of get out your organizational tree and look at that and make sure you know where positions are going to be reporting, particularly for those remote and hybrid positions. If you're looking for a time sort of against my recommendation where you don't have to apply, or a position that you don't have to apply the pay transparency range to. But for the most part, again, we're going to just apply those to most new positions, certainly beginning in September, if you're not doing that already. I think this is a good opportunity to update job descriptions, although they aren't required, and we'll talk about that again in just a minute. They are encouraged, I would say. It is a best practice to have job descriptions for the vast majority of job positions that you're going to be posting for. And this is a good opportunity to review those essential functions and qualification standards. If you haven't done that in a while, those are things that should be updated regularly, particularly they're helpful for things like ADA compliance. They would be helpful if you're going to end up defending any kind of pay equity challenge or regulatory or litigation. And then really, this is a good time, and we mentioned this a few times. If you haven't done a pay equity and compression analysis, now's a good time to do it. That will be very, very helpful to you if you are challenged on any kind of pay equity issues. It gives you an opportunity to find out what an investigator or a plaintiff may find out before they do, and gives you an opportunity to address any kind of discrepancies. Certainly, you can do sort of targeted small equity analysis of your own in order to, or along with counsel, in order to identify outliers, but you really aren't going to be able to identify sort of statistical deviations across a broad range of characteristics without some help. We can help you with that. Bond can help you with that. You do want to work with counsel when you're doing any type of pay equity analysis. The last thing you want to do is create a document that's going to be used by a plaintiff or by a regulatory agency that they're going to get through discovery that's going to end up being their Exhibit A and identifies exactly what they want to identify in terms of problems with your pay equity structure. But now's the time to do it, because as we become more transparent, it's going to become easier for people to identify potential equity issues on their own and attempt to address those through regulatory action or through litigation. Now's the time to do it on your own. But again, work with counsel and make sure we keep that privilege. Next slide, please. So these are just a few of the common questions that we get around this area as employers are preparing to apply the new pay transparency laws. Can we agree to salary outside the posted range? So you post, say, the job from 75 to 100,000, and you get somebody really competitive, somebody who is overqualified maybe, but you have an opportunity to hire, but they want 105. Generally, my suggestion is that you default to a reposting of the position. You may get additional applicants for the position that you wouldn't have got at the former range that you applied. But I understand sometimes we understand that you may want to strike while the iron's hot and hire this good candidate that you have, even though you're going to pay them a little bit more than the range. As long as at the time that you posted the range, that was your good faith estimate of what you were willing to pay, then technically you can pay outside the range. However, what we would recommend is generally you default to a reposting of the job at the new range, and then allow for someone like a hiring supervisor to sort of make an appeal, probably to your human resources office, and say, we really should just go above the range on this one. If they do that in writing, then you have contemporaneous documentation explaining why you went outside the original range, which is what you really are going to need someday if anybody challenges that. So there's no specific prohibition on going outside the range. It is disfavored, but I think that sort of exceptions can be made to the general rule that you repost. And those exceptions should be documented. The reason why you're making the exception, again, a good way to do that is to have someone like a hiring supervisor, the person who's asking to pay more outside the range, pay above the range, to be able to document that and explain to someone, to some kind of gatekeeper, like a human resources office. Do you have to include a job description? No, you don't have to. What the law says is if there's a job description, then you have to include it. Now, again, we recommend generally that you do have a job description for most positions that you're going to be posting. It's generally best practice. Helps you when it becomes time to do a performance evaluation. It can help you defend an equity claim if two people are claiming that they do the same job when really they have different job descriptions. It can help you when you're determining what may be a reasonable accommodation as you look to things like qualifications and essential functions. So all those are good reasons to have job descriptions. So generally you should have them, but you don't absolutely need one that the law does not specifically require. Can you still ask applicants about their salary expectations? This is not strictly prohibited by the law. I would say, again, this is something that's sort of disfavored. It cuts against the general intent of the pay equity legislation, both this legislation and the salary history ban that we all know is in effect. This sort of can appear to be, I think, if you're asking for salary expectations, sort of an end run around salary history bans against asking about that. Because what are you really asking? You're really asking, what do they expect to make now based upon what a good portion of that is going to be based upon what they currently make. So you don't want to do anything that looks like you're making an end run. It's not strictly prohibited, but probably disfavored, probably not a good question to be asking unless you have a really good reason that you can identify that you need to ask about what their expectations are. And again, if you're posting a range and somebody's applying for the job, presumably their expectations fall within that range. So you've already covered part of it. If you're already compliant with local laws, particularly the New York City law, which is going to apply to the vast majority of employers, certainly in the metro area, if not beyond, then what else do you have to do? Again, looking at those job descriptions, which is a separate requirement, is one thing you may have to do, and certainly you're going to have to be prepared to apply to a broader range of employees. Again, my recommendation at this point is just to kind of default that you're going to apply a salary or include a salary range in all postings going forward, rather than look for exceptions where you don't have to. But even if you are looking for exceptions, you're going to find fewer of them now because the state law has broader application than the city law. Other than that, most of the differences are differences in enforcement. That's it for me. Thank you.
Thank you, Seth. Appreciate that. There are a number of questions in the Q&A if you want to take a look at that. I'm going to put you on the spot though here with one of them. So I just see a repeated question here about jobs that don't necessarily have a range, that they are what they are. There's a rate and that's the rate that's going to be paid. Is it okay to, the question is whether it's okay to just post that amount. Any thoughts on that?
Sorry, yeah, you're gonna be posting the range of the job that you're actually posting, not what it was or what it may be for other employees. It's what you're actually looking to hire someone into that position at whatever rate it may be, whether that be hourly or salary.
Okay, yeah. So, but as I mentioned, there's a bunch of questions if time allows. Definitely a topic that a lot of people are thinking about. So appreciate your time. I should have mentioned that you're in our Buffalo office and available, to answer further questions out, across the state. But thanks, Seth. Next, I'm going to move over here to Syracuse. Colin Leonard, a member in our Syracuse Labor Department, is going to talk about the WARN Act. Go right ahead.
Thanks, Kristen. Hello, everyone. Good afternoon. Just want to give you a brief update on the New York State WARN developments. just by way of background, New York State WARN is a law like the Federal WARN Act that requires advance notice prior to conducting either mass layoffs or plant closings. The law has been in effect since 2009, and we've had the same regulations since 2009. And the law was intended to really reduce the size of the mass layoff or plant closing that needs to occur in order to require the advance notice for the layoffs from what the federal WARN requirements are down to a smaller number in New York, and also to provide a longer notice period than does the federal law, which is 60 days and it's 90 days under the New York law. So as I said, these regulations have been in place since 2009. There were proposed regulations issued in March of 2023. There was a 60-day notice and comment period that was provided, and then these new regulations revising various portions of the initial regulations were made final on June 21st, 2023. I would say, just by way of background, what also came out over the summer was a New York State Comptroller's report by Tom DiNapoli, indicating that the New York State Department of Labor had essentially dropped the ball to some extent during the pandemic with respect to WARN issues. And it was understandable, according to Mr. DiNapoli, because the department was really focused on, the agency, New York State Department of Labor, was really focused on unemployment insurance benefits, and issues relating to WARN really fell through the cracks, so to speak. So maybe these revisions were intended to address some of those issues, but I just wanted to make that point as well. So the proposed regulations, again, that were issued in March of 2023 became final in June of 2023. There were no changes made through the notice and comment period. I just want to say I've presented on this already in the webinar series, so I just want to make 3 points for your consideration as you think about WARN. Just be sure, if you're considering, your organization is considering layoffs or separations, permanent separations, be sure you include WARN in your analysis. It can be implicated with as few as 25 layoffs. And the tricky part about WARN is there are these aggregation windows when you need to add together layoffs or employment losses that occur over 2 different windows. One is a 30-day window, and then one is a longer 90-day window. So you may be thinking you've got smaller layoffs that are occurring and they do not implicate the WARN notice requirement, but very often they can. And the hardest part about WARN is once you trigger the law, let's say you've triggered it over a 90-day period, you've actually violated the law with respect to those earlier layoffs and separations, within that 90-day period. So it's kind of like, the so-called, putting toothpaste back in the tube. So it's something to think about early on in your process. Number 2, regulations now require remote workers to be included in the analysis under New York WARN. So if they're working remotely in New York, from the site in New York, they're counted. If they're working remotely in Utah, but they're reporting to a site in New York, they're counted for purposes of this. So again, it's going to require, I think, a more thorough analysis to include not just people at the single site of employment, let's say in Manhattan or Albany, but other locations as well are going to have to be factored into the consideration, again, based on where that remote worker is reporting to within New York. And finally, I think the other thing to think about, and this is where WARN often becomes more of an issue, is when you're dealing with business transactions for the organization, where the organization is selling off all or part of the organization or the entity, or they're acquiring another entity through the process of that transaction. Very often, the asset purchase agreement or whatever transactional documents are involved in the case or in the matter will talk about employee layoffs or employment separations. And so again, because the Warren Law assigns liability based upon when these employment losses occur, if any, in connection with a transaction, you certainly want the language in your transactional documents in your APA, for example, to line up with what the parties intend to occur, and that you've appropriately captured how employment transfers from, let's say, the seller to the buyer are going to occur in the context of that transaction. Again, we're here to address any Warren questions you may have in the context of any employment situation you have. Feel free to reach out to your favorite bond attorney at that time. That's it for me, Kristen. Thank you.
Thanks, Colin. So we're going to turn our attention now to a non-labor topic. We have Kurt Johnson from our Rochester office to talk about a case he's been involved with. Go right ahead, Curtis.
Thanks, Kristen. That's right. So a non-labor topic for our labor meeting. But this is an interesting one, and I'm going to tell you a little bit of a story. So last month, Justice Mark Masler, New York State Supreme Court, that's our trial level court in New York, sided with Bond's client, Ithaca Renting Company, and found that a provision of the New York human rights law aimed at making landlord participation in the federal Section 8 housing program mandatory was unconstitutional. And a little bit of background. So the Housing Choice Voucher Program, which is known as Section 8, was first enacted in 1974 to provide housing subsidies to low-income tenants in both housing projects and privately owned rental units. It's governed by federal statute and regulations that are enacted by the U.S. Department of Housing and Urban Development. Congress intended Section 8 to be a voluntary program that landlords could participate in as a means of attracting tenants with the security of knowing that the federal government would provide a portion of the rent. HUD's regulations regarding Section 8 participation are numerous. The regulations give rise to contracts that between a landlord and the tenant, a lease, and between the Public Housing Authority, which is a local agency, and the landlord, and that's known as a Housing Assistance Program contract, or HAP contract. The PHA, the Public Housing Authority, will only permit a landlord and tenant to participate in Section 8 if it determines that rent is reasonable, which means it cannot exceed what the PHA determines to be market rent. Only certain residential units meeting housing quality standards and price requirements can be rented under Section 8. PHA is responsible for inspecting housing units to be rented, along with the remainder of the building, to ensure compliance with housing quality standards, such as the presence of sanitary facilities, i.e. a bathroom, food preparation, refuge disposal facilities. They'll look at the square footage and the number of bedrooms per number of tenants, the thermal environment, whether it's heated or not, illumination and electricity, structural materials, interior air quality, water supply, whether there's lead-based paint, how a person can access and get out in case of a fire, site and neighborhood safety, sanitary conditions, and whether or not there's smoke detectors. Landlords that want to participate in Section 8 have to execute a HAP contract. That's a form that was created by HUD and can't be changed. And it includes a landlord's agreement that, quote, the PHA may inspect the contract unit and premises at such time as the PHA determines necessary. It also requires that, quote, the owner must give the PHA any information requested by the PHA on rents charged by the owner for other units in the premises or elsewhere. And most importantly, Part B, paragraph 11 says that sub A, the owner must provide any information pertinent to the HAP contract that the PHA or HUD may reasonably require. Sub B, the PHA and HUD and the Comptroller General of the United States shall have full and free access to the contract unit and the premises and to all accounts and other records of the owner that are relevant to the HAP contract, including the right to examine and audit the records and make copies. And Part C, the owner must grant access to computerized and other electronic records and to any computers, equipment, or facilities containing such records, and must provide any information or assistance needed to access the records. This means that the PHA and HUD, which includes armed special agents that every federal government agency has with arrest powers, are granted access to computers, equipment, and facilities containing records. That almost certainly means personal smartphones and computers at this private residences of owners. And access is not limited to reviewing records that are directly related to being a landlord. In order to confirm that the government has all of the records that are relevant to a person being a landlord, it's most likely going to look at all of the non-relevant information on a smartphone or a computer to determine its relevance. In 2019, New York State amended Section 296 of the Human Rights Law to make it unlawful for landlords to discriminate against potential tenants based on a lawful source of income. And lawful source of income was defined in Section 292 of the Human Rights Law to include, quote, any form of federal, state, or local public assistance or housing assistance, including but not limited to Section 8 vouchers. The Division of Human Rights then passed a regulation requiring PHAs to post notices to tenants that it would be unlawful for a landlord to tell a tenant that it did not participate in Section 8. Ithaca Renting Company, Bond's client, has never participated in Section 8. It accepts other forms of vouchers, including vouchers for security deposits, but when potential tenants come to them asking about whether or not they will accept Section 8 vouchers, Ithaca Renting Company staff informs tenants that they do not participate in the voluntary federal Section 8 program. The Division of Human Rights and later the Attorney General commenced proceedings against Ithaca Renting Company to compel compliance with the Human Rights Law. Ithaca Renting Company, citing to a New York Court of Appeals case from 1981, which was in turn based on a U.S. Supreme Court case from 1967, argued that, quote, it's beyond the power of the state to condition an owner's ability to engage his property in the business of residential rental upon his forced consent to forego certain rights guaranteed to him under the Constitution. In that case is Sokolov v. Village of Freeport. Sokolov involved a local ordinance that required landlords to, quote, obtain a rental permit prior to leasing any part of a residential dwelling, and to, quote, no permit could be issued without inspection of the premises to confirm it was safe, clean, sanitary, and in good repair and free from rodents and vermin. The Court of Appeals found that the imposition of a forced inspection on anyone wishing to lease the property as a residential tenant on penalty of fine of $250 a day for failure to comply violated the landlord's Fourth Amendment right to be free from warrantless search and seizure. The same time that they decided Sokolov, they also decided Pashkow v. Town of Babylon. In that case, a statute actually had a provision where the inspector, if it couldn't gain access to the estate, had an opportunity to go get a warrant to compel inspection. And the court essentially compared the two statutes. And where there's a provision allowing a warrant, the statute was okay. Where there's no warrant consideration in the statute, it's not okay. Because Congress and HUD view Section 8 as a voluntary program, Section 8 regulators do not envision a circumstance where a landlord would voluntarily agree to participate in Section 8 and then refuse the PHA or HUD agent's entry. And so there's nothing in the federal regulations that would permit inspectors to go get a warrant. Because mandatory participation in Section 8 would require landlords to sign HAP contracts, and HAP contracts specifically consent to inspections of premises and computer devices, the state has violated the holding of Sokolov by conditioning landlords' ability to rent property for residential purposes on consent to consent of waiver of Fourth Amendment rights. New York State is preempted from altering the federal HUD regulations, so it can't simply amend the way Section 8 is applied in New York to save its statute. And New York is one of approximately 20 states with source of income laws, although not all states specifically define a Section 8 voucher as a source of income, and in fact, some states carve it out. Many municipalities around the country, including Erie County and the city of Buffalo, have similar laws. Sokolov has been followed in many states. State versus Ithaca Renting Company appears to be a case of first impression in New York and really anywhere in the country other than the Sokolov case, which it's based on. And the state has already filed a notice of appeal. I've gotten some comments and questions from potential landlords and also from the press about this. One of the things they've asked is whether or not this decision applies immediately in their case as a landlord or to any landlord in New York State. No injunction was issued by the judge in this case, so it doesn't have immediate effect in precluding the state from enforcing this law other places. It's certainly persuasive authority, and anyone who's facing a compulsory Section 8 participation could cite to this case and potentially convince their judge in their case that this should be the law that is followed. And once it gets to an appeal, and then, like I said, an appeal has been filed, depending on who wins the appeal, that'll define the law for the rest of the state. So stay tuned, and we may be updating you in the next year or so on where this stands.
Thanks so much, Kurt. Appreciate it. And we're definitely not a labor-only webinar about all topics that interest businesses, even though we tend to sometimes, particularly in my weeks, have a labor-heavy agenda. So always welcome to come and talk about different topics applicable to businesses. And so for the final presentation, I will actually be handling that one myself. And, in addition to providing content about new legal developments to our clients, we do sometimes include sort of basics about different topics that we think may be of particular interest or sort of applicability to your day-to-day business. So just last week, one of the practice areas at our firm is focused on municipalities. So Bond represents quite a few municipalities, towns, villages, cities across the state. And we did a webinar last week or 2 weeks ago, actually, where we talked to those clients about their obligations to release documents under the Freedom of Information Law, or FOIL. And so, and actually what I realized when we did that was that some of the attendees were not from municipalities, but were from private businesses or nonprofits, which made me realize that our clients that are not within the government are interested in understanding this to figure out how they can receive information and documents from the government. So I thought I would take some of the content of that webinar and share it with this audience. So if there are any of you on here who did listen to Kristen Warner a couple weeks ago, this is a little bit of a repeat. But anyway, if you could advance the slide, Kathy. So the Freedom of Information Law, which we refer to as FOIL, is part of New York State Public Officers Law. And that's just the law that requires all government agencies at every level, state agencies, village, town, cities, school districts, et cetera, to maintain the availability of certain records and make them available for public inspection, copying, and provide them to anyone who requests them. Can you next slide, please? And under FOIL, each agency, and when I'm going to say agency here, I'm talking about any level of government. Each agency has to have written rules and regulations pertaining to their availability of records, so that people can understand, when the time and place that records are available, who you should be asking for the records. So who is the records access officer? That'll be a different person in every type of government. And actually the fees, or what fees you might have to pay for receiving records. Next slide. So the rules are that agencies have to make records available for inspection and copying at all reasonable times, any time that the entity is regularly open for business, and that really any member of the public can come and inspect or request copies of documents. You don't have to have a particular reason. You don't have to explain why you would like the documents. If they are public documents, you can ask for any reason. And when you're going to inspect them in person, there's no charge. We will get into fees later in this quick presentation. Now, if there's something in the document that should be redacted, the agency can tell you that you can't physically inspect it because it needs to be redacted. Then they can separately redact the document and provide it in redacted form. And if they provide that in paper form, that there would be a charge of 25 cents per page. Next slide. And what do we mean by government records? Like, is there a particular definition? And really, I have it on here on the slide, but it's incredibly broad. Any information kept, held, filed, produced, or reproduced by, with, or for an agency or the state legislature in physical form whatsoever, in any physical form whatsoever. So there's really no limit to what is defined as a record. There are exceptions to what needs to be provided by the government agency, but the definition itself is very, very broad. And so I put some examples here, but this is certainly not an exhaustive list. So letters, emails, text messages from government officials, contracts, vendor data, invoices, So anything sort of documenting the business conducted by the agency. Permits, code documents. So if you're interested in finding out what's going on with the property and that your business is interested or neighboring your business, you can always request permit documents, any documents about code enforcement. If there's a troubled property in your area and you want to find out if it's subject of code violations, you could request those. Certainly police and fire reports are very commonly requested. In the advent now of the use of body-worn camera footage by many police agencies, that footage is subject to request and disclosure. And, in our labor world here, if you're interested in finding out, what the terms and conditions of employment are for public employees, maybe you're a public employer, you want to know what the city down the thruway is doing, you can request, final copies of collective bargaining agreements. And I have to sort of put in here, I sort of have, for a time over the past few years, I worked for the city of Syracuse as their corporation counsel, and our office was responsible for responding to FOIL requests. And it always amazed me how frequently individuals and businesses request public records. The city of Syracuse received over 1,000 requests a year, and I can't even begin to describe the wide range of things that were requested. This list of 6 bullets is very, very small sampling, but any electronic or paper record that exists within government can be requested. Next slide. Now, I said records is very broad. Well, certainly there are exceptions to what you actually can request, and I'll run through these exceptions really quickly here. If a record is exempt from disclosure by another state or federal statute, you won't be able to obtain it. So certainly if you're talking about a school district, they're governed by the Family Educational Rights and Privacy Act, otherwise known as FERPA. Those keep certain student records private, and so you can't get those. If the client is privileged under the attorney-client privilege between the agency and their counsel, you won't be able to get that. And there are other laws as well that might apply. There's also an exception for unwarranted invasion of personal privacy. It's a very heavily litigated exception, and often comes up when you're talking about employee personnel records that are being requested. It doesn't protect all employee personnel records, but it does protect some of them. Documents that might impair present or imminent contract awards or collective bargaining negotiations can be withheld for obvious reasons, right? A business who is bidding on public work cannot, request documents, in the middle of a bidding process to find out what their competitor might be bidding, for example. Or if someone's negotiating with a public entity, trying to retrieve information that might help them in that negotiation. Those are exempted. Certainly trade secrets. So if you as a business give records to say a city, because you're doing business with them, and you indicate to that city or that village that that's private information protected by is a trade secret or something like that, then the public entity is supposed to abide by that restriction and not turn it over. Next slide. Now, records that are compiled for law enforcement purposes are often protected from disclosure, certainly if it would interfere with a law enforcement investigation. So if you're looking for a police report of something that happened recently and it's still under investigation, you likely are not going to be able to get those records. If a record would deprive a person of a fair trial, those would be withheld. Obviously, if something would identify a confidential source or disclose confidential information about a criminal investigation, or reveal criminal investigative techniques. All of those things can be lawfully withheld by a government entity. And certainly if something would endanger life or safety, that can be withheld. Next slide. In the school district context, a savvy student could not foil the examination questions or answers before a test to try to get a leg up. So that's an exemption. And computer access codes cannot be requested from an agency. And finally, there's an exception called intra-agency, and that has its own slide. If you could move ahead, Kathy. So the idea here is that governments, although all documents are considered public, they should be allowed to engage in some level of deliberation internally and not worry that every bit of documentation about that deliberation is going to be public. So if something is not yet final and not really factual, and it's a communication between agency officials. So between employees within a government, or between two different governments. So between, say, a town and a state official, if it's not a final communication, often that can be withheld, just to protect that deliberate process. Now, if something is statistical or factual, it has to be released. If it's a final agency determination, we've deliberated about a particular topic, but this is our final say, our final policy, that cannot be withheld. If it's an instruction to staff to tell staff how they should handle a particular situation, that cannot be withheld. And external audits cannot be withheld. But other than that, there are a number of documents that will be withheld because they're considered deliberative. Next slide. Now that's sort of the overview of what can be requested from a governmental entity in New York State. Now I'm just going to quickly cover the procedures of how you would go about to request public documents. The first thing is you put a written request in and to the records access officer. In my experience, if you don't know who the records access officer is, it will be forwarded to that person within the government. But they have an obligation, the government has an obligation to, within 5 days, do something with that. So it's a very, very quick turnaround. And within 5 days, the government has to either provide the record, make it available, or deny it and give a reason in writing why the request is being denied. For example, one of the exceptions I just described applies. Or say, we got your request, we're working on it, and here's the date when you will receive it. This is probably the most common request that I've seen, because it is difficult for government agencies to respond to the volume of requests they receive within just 5 days. So you should receive a letter back from the government saying, got your FOIL. You'll have a response in 1 month, 2 months, whatever that is. It has to be a reasonable amount of time, and that will depend on how large and onerous the request is. Next slide. Now, if there's something called a constructive denial, which is if the government doesn't get back to you within 5 days, or they delay responding for an unreasonable amount of time, that can be considered a constructive denial. Essentially, even though they haven't outwardly said no, you can treat it like a no and go straight to the appeal process. Next slide. Now, if requests cannot be fulfilled within 20 days of the acknowledgement, the agency actually has to explain why. And when they give that reason, or when they give a date for when the record will be released, they have to give a reason. For example, due to the large volume of FOILs being received, or due to the complexity of the request, or something like that. So there should be, in the written response that the government gives you as to why they need more than 20 days, there should be an explanation. Next slide. Now, a question that we get from our government clients when they're trying to figure out how to respond to FOILs is, this is just extremely onerous request. Can we deny this because it's just overwhelming to our staff? And the answer is no. There's no limit in the Freedom of Information Law based on volume or burden. The government agency can take more time to reply as needed to be able to compile the information, but there cannot be a denial just based on the size or the burden of the request. And if the government agency lacks sufficient staffing, as it says here in the second bullet, it can ask for outside professional service to help comply with, to reply to the request. Next one. All right. The other thing is sometimes individuals or businesses will make a request of a government that's actually asking the government to create a document that doesn't exist. And in that case, it's appropriate for the government agency to deny that. FOIL does not require a government agency to create a record where one does not exist. However, if there is, for example, a database where the data can be extracted into a report, technically that report didn't exist, but the data underlying the report does exist, the government would be required to generate that report. And in my experience, sometimes it's easier for the government to provide a summary report than it is for all the underlying documents. And it actually serves the purpose of the requester. And so there can be an agreement that that's how it would be done. So, if I want to know about all the code enforcement violations in a particular month, instead of providing every single underlying code enforcement document, the government could say, well, we'll give you a report. And sometimes that will work out. And if there's necessary programming to retrieve a record in a computer system, that's not considered to be creating a new record. That's another way of saying what I just said. Okay, next slide. And I realize we're just about a minute over here, just a couple more things that I thought I'd explain. The government can charge 25 cents a page, or if they're providing it like on a flash drive, they can have you pay for the flash drive. My experience, though, if they're transmitting the documents in email form, which is very common now, there is no charge. And there can be a requirement that you pay in advance of the preparation of the copies, and the government cannot charge for the time spent by the employee copying the documents or searching or scanning them or redacting them, which actually can be kind of a high cost for government agencies at this point. But they cannot pass those along to the requester. Next slide. You can make an appeal if you request something for a government and are denied, and you think they got the law wrong, you think that they're interpreting FOIL incorrectly, you can make an appeal to the head of the agency, the chief executive or the governing body, whoever that agency designates as their appeal officer. And then the response to that appeal has to be made in 10 business days and has to explain why the appeal is being either requested. I'm sorry, either not requested, the appeal is either being granted or denied. Next slide. The appeal response has to specifically explain why access is being denied. Appeals have to be filed with the Committee on Open Government, who kind of oversees all of this from the Department of State. And next slide. Finally, after all of this, after you've requested the document, been denied the document, filed an appeal, got a response on the appeal, at the end of that road, there is an opportunity to go to court. And you would file what is called an Article 78. And a court would then make a determination of whether the document should or should not have been withheld or should have been produced. And there is an opportunity for attorney's fees if the requester does prevail and the court finds that the agency really didn't have a reasonable basis for denying the request. So it can be a long road, but we have seen circumstances certainly where these issues go to court. The FOIL law is actually litigated more than you would realize. And so we do often advise government clients on how to respond to FOIL requests. We also help clients sometimes through the process on the other end. And so if you have any questions about FOIL as it comes up in your particular business, feel free to reach out to any bond attorney who you deal with. So that's the end of my piece here. I want to thank all of you for coming and attending this webinar week after week, for being so engaged with your questions and suggestions for topics. We're always looking for new topics to present to this audience. And if you have any, send them our way, and we will see you again here next week, next Tuesday at noon. Thank you so much.